Hey there, this is Karl Isenburg at My Home Group, and I'm a associate broker, and I've been selling real estate here for over 22 years, and I've got a small team, and I've found that so oftentimes, whether it's myself and my clients or my team members' clients, we get so busy, especially in this crazy market that we're in, to where we're in a hurry, our buyer's in a hurry. It's like, I got to hit the button, I got to buy the house, I got to make the deal, and we're really good at winning. It's important, though, we also focus on what's most important, which is you, our client. We want to make certain that you know what's going on, what's going in the contract. So this isn't particularly for your specific contract, but we want to give a quick overview of what's going on and the documents that we're presenting to you that you probably have filled out and signed, and hooray, you're under contract. I'm going to take, if you can take a bit here and listen to my overview, and if there's something that we missed, please reach out and we'll get it to you. And if there's something you don't understand, we'd love to explain it to you. But we know how busy you are and how much is on your plate. So we're trying to make this as efficient as possible. So first and foremost, I'm going to share my screen. So you're going to probably just be hearing my voice, right, as I go through this. But I wanted to get you up and looking at the most important thing that we may not have given to you, but we should have, okay, which is the buyer's advisory. This document, we want to give you the link because you signed it in the document, but we want to send you this PDF with the live links. Like, you want to know what a subdivision is. You want to know what's up with these home warranties. I want more information about home inspections or termites, or what is FERPTA, for goodness sakes, Foreign Investment Real Property Tax Act. What's that mean? We'll explain it to you, but it's always nice to calmly have the opportunity to go back and check it out. And this buyer's advisory, this one document with all these live links, it's got all the answers pretty much. Okay. Even to where, you want to look at property boundaries, you want to look at stuff. So sorry I take so much time on this, but people want to know what's going on with crime, what's going on with sex offenders, and what about military airports. All that stuff is really important. Hence, we want to make sure that you know about it, and we're giving you that information. And the next most important thing that we're going to talk about is agency. Well, what's agency? Agency is who we are and who you are, and what is our relationship to you. And as a buyer broker, we represent you, your best interests, not the sellers, not us. Okay, it's not the lender, not anybody. It's you. What's in your best interest? We have fiduciary duty to you, and sometimes people forget that in the haste of things. We'd rather walk away from the deal, walk away from the income if it's not in your best interest. We want you to know what's going on. And that's why we do this disclosure. We'd say, hey, we represent the buyer as a buyer's broker, and we're representing you that way. Well, also, we may have one of our listings that we got you in fast and furious and you're buying it, but we represent the seller as well. We have to disclose that to you. We have to make sure that you know the scoop on that. So those are two important early features. Okay, and jumping into the purchase contract. I know I'm clicking along on time. Don't want you to get bored. Okay, but here you go. Moving into the buyer attachment of the contract. And the first page, people get bored with this, but it's important. Read the contract, what CCNRs are, and those are the things that are in bold. Whenever you see something in a contract with bold lettering, it means it's important, and you really need to focus on it. Section 1 of the contract is broken. Our contract's broken up into 9 different sections. Section 1 is about the property, and in the property, though, it talks about who the buyer is, who the seller is, what's the address, what's a legal description, what's the purchase price, how much earnest money you're going to put down, and how are you going to do that? We usually like to say within 2 business days of contract acceptance. And then, are you getting a loan? Maybe you're paying cash. We want to put those details down. Then how are you sending that money over to the escrow company? We like to say personal check or wire. We like to say, within 2 days, because if you don't say that, it has to be right there. When is close of escrow? Close of escrow and addendum, and possession. People don't understand what that means. It means that all the funds come in, they go to the title company, and it's all finished, and they send it out for recordation to the county recorder's office. So you got to go through the Federal Reserve, you got to go through all that. Then they send it to the county recorder's office, and it records, and they get confirmation of that recordation. At that point, you have closed escrow. That's what it's involved. So that's why a lot of times, even though the lenders funded it early in the morning, sometimes it takes till 4:57 in the afternoon before it happens. If you want to get possession, after close of escrow, it has to be negotiated. We got to make sure we note that. Then we got this thing called addenda incorporated. Well, why? Who cares, right? It's just another document. But if it's incorporated or put into the purchase contract, then all the other aspects of the contract apply, as well as the addendum that we're including. Okay, so I'm going to jump off of this first page, and I'm going to come back to some of those important addendas. One is the additional clause addendum. It's kind of a goofy document because it depends on which part you like, but we like to be able to use pre-written, safe, standard language so that our clients protect it. Okay, if you want to do a backup contract, maybe there's an absent spouse or it's a relocation. Maybe we're getting super aggressive and we're saying non-refundable earnest. Well, how does that work? Well, what if we waive the appraisal? How does that work? Or what if we say there's an appraisal shortfall? Or if we're doing a tax deferred exchange or something to do with water. But those things, it's an important document, and it's like we're adding that clause into the contract itself. The other really important document, not every home has a homeowners association, but a big chunk of them do. And this first page of the HOA addendum, the seller is responsible for saying, who is the HOA? Who is the management company? How do we get a hold of them? What are the transfer fees? Are there capital improvement fees? We've seen situations where we got capital improvement fees of $2,000. That's material, and who's paying for that? By law, the seller has to pay the disclosure fee. Okay, but that's only by law it's stated. Everything else has to be negotiated. Is the buyer paying it? Is the seller paying it? Are we splitting it? And oh, by the way, if something's not correct, okay, who's responsible for? In fact, this page is actually not accurate because we're missing a sentence we added in. But who's responsible for the HOA fees? We have to make sure we communicate that. So those are the important docs, and I'm going to talk about this because this is in section 2, which is a pre-qualification form. By our contract, it has to be noted in the contract and attached to the contract. This is what the lender will put together. At the very least, you have to have lines 1 through 40 signed by the buyer. But you know what? If it's not completed by the lender and you're getting a loan, you're not going to get the house. I mean, unless the seller is just crazy, it won't happen. It's important to know what that document is. So coming back to the purchase contract and moving you along here. So that's what section 1. I went through the additional addenda that's included in the contract usually. Notice if you were getting septic, you'd have an on-site wastewater. If you had a solar lease or something on the solar, we'd have a solar addendum. If the home was built prior to 1978, we'd have a lead-based paint addendum. All those things are important. And then also there's a big section about fixtures. We always ask who, refrigerator, washer, and dryer. It's important. Are they conveying, not conveying? It matters. And also all these things that like, what about wall-mounted TVs? What about that Ring doorbell by the front door? Those things all convey, but the bracket conveys, but not the TV. It's confusing sometimes. So we talk about fixtures, and when all these little line items here, they're here usually because someone probably got sued at one point regarding a garage door opener. I'm taking that with me. Well, we got to pay attention to what it is our buyers are expecting and what the seller's contractually bound to. Section 2, financing. Remember I talked about the pre-qualification form, the PQF, right there, line 69. It's part of our contract. It says you have to do this. It has to be attached. And so if it's not attached, you got to do something about it. And the most important thing, which is awesome for our buyers, this is such a buyer-friendly contract, is there's a loan contingency. This loan contingency means that you have to, if you do everything you're supposed to do and you try as hard as you can, but yet you can't get qualified to purchase the home, guess what? You've got a way to get out with an unfulfilled loan contingency, and you can get all your earnest money back. But you must have it. We got to, the realtor, we have to get notice to the other side, okay, no later than 3 days prior to the close of escrow. You try and do it the day before close of escrow, there goes your earnest money. Same thing goes if interest rates jack up or you don't have enough cash to put as your down payment. That's not a good enough excuse to get out of the deal. But that's still a huge, huge opportunity to protect our buyers. Then it talks about things that we haven't seen in this current market, seller concessions. Hopefully we'll get to the point where seller says, fine, I'll give you $5,000 towards your closing costs. That's not happening right now, but it should be. Guess this section 2K, important. guess what? A buyer can change lenders. They can do those things. It matters. You got to pay attention to the details, but you have a right to do it. Okay, so long as it doesn't, you can do it without the seller's written consent. So long as it doesn't prohibit you from closing and financing the house. So generally speaking, we always like to let the seller approve it. It makes it better. And then, of course, the most important issue here at the end of the financing is the appraisal contingency. A lot of times we're waiving that these days. Sometimes we're getting, we have, some lenders are foregoing that and letting it, not having it because there's so much equity in the house. But bottom line is the way this standard contract works, the home has to appraise for at least the purchase price. And if it doesn't, the buyer gets to cancel. It's a great way to negotiate a reduced purchase price. It's important though that our buyers understand, okay, that you might be in this deal $1,000 for your home inspection and your appraisal. Those are sunk costs. But I'd rather lose $1,000 than buy a bad house. Section 3, title and escrow. In a nutshell, you're agreeing to hire a title company to do all the work to transfer the ownership from the seller to the buyer, and from the seller to the buyer. And both parties agree to that. It's a non-involved third party, but they're the ones that hold the earnest money. They're the ones that make the decisions on that. They prorate the taxes, and they're the person that they do a lot of heavy lifting to make sure that everything gets taken care of. There's a disclosure, section 4. Seller's got to tell the truth about any hidden latent defects. We provide a seller property disclosure statement, which is a tool that helps the seller disclose things that might be material to the buyer. Then they also need to give an insurance claims history within the last 5 years or how long they've owned the home, if it's less than 5 years, if they've ever had any insurance claims. Our buyers need to know these things. They need to know these things in the inspection period. Then, of course, the FERPTA foreign sellers, which doesn't apply unless it does. And if it does, it's very important that the buyer gets it, because the buyer is the one that's on the hook. So we got to make sure that we know what's going on with the seller. Lead-based paint disclosure, a big section on lead-based paint. It was been prior to 1978, there's lead-based paint. So no big deal, but it's a federal form that has to be on the contract. Affidavit of disclosure, that's for properties outside of a municipality. They're not in the city. They're just like a county island. We have them, they're out there. And we don't run into it very often, but it's one of those things that explains, is it fewer than a subdivided property, et cetera, is it outside city limits? And then changes during escrow. If there's a fire, there's a flood, something happens to the house, the seller has to disclose it. Okay. And then we move into warranties. Used to be we warranted the air conditioning system works and such. Doesn't happen anymore. Buyer and seller agree that this home is being sold in its present physical condition. That's like the way it is. So the buyer beware, right? Buyer's got to get out there and figure out what's wrong with the house or what's right with the house. Now, things that do survive the closing, okay? The seller, let's say the seller fibs or pretends to say they didn't know something, but they did. That survives the closing. They had a flood, didn't tell you about it, then you find out there's mold. That buyer has a right to sue that seller, and they will have a super high likelihood of winning. In fact, I don't know where they don't. So as long as you can prove it, it's something that survives that closing. And the buyer warrants promises that they're telling the truth, and they're not relying on verbal representation. Now we move to section 6. Hope I'm not going too fast or too slow, but I'm doing the best I can to get you the information. This section is, well, it's my favorite, and it's one of the more important ones because it's all about buyer due diligence, okay? Your inspection period. The standard inspection period is 10 days. We see sometimes we got sophisticated buyers that can turn and burn in 5 days, or they're buying a fixer-upper. They know a bunch of stuff's wrong, but generally speaking, the standard inspection period is 10 days so that you can do all the investigation you need to do. You do the home inspection. What if you need to get a roofer out there? What if you need to get an AC person out there to inspect stuff? We have to check for termites. If we don't check for termites, how do we know? But it's material. Flood hazard. Is it in a flood zone? It's important. How much is my homeowner's insurance? Wouldn't it be horrible if you assumed it was $500, only to find out it's in a flood zone and it's going to cost you $2,000? Those are important things to ask. Make sure it's on a sewer system. Make sure you have the swimming pool barrier regulations. I think we all know about those, but we have a disclosure that, hey, they're there. And then a big bold thing that says, please note, okay, the realtors are not to be held liable for defects or conditions that could have been discovered by an inspection. That meaning we're not inspectors. We do the best we can, but it's important that the buyer doesn't just assume that the realtor knows these things, because we don't unless we're, licensed for that. Our team, we're very diligent in that regard, but not all of our peers hold to that. So anyway, it talks about the inspection. Notice after 10 days, you can have three choices. You can say, I'm out of here, I'm canceling it. It's at buyer's sole discretion. It's pretty awesome. Alternatively, you can say, you know what, this home is fantastic, I'm just proceeding. And then you accept it and you proceed to close. Or you can say, gosh, you know what, I found some things that I disapprove of. And it gives the seller an option to make those things right. Okay. So once the seller receives it, they have 5 days to get back to you with one of three choices. One, I'm not going to do anything. Sorry. That's option one. Option two is, it's great. I'll take it just the way it is. I'm proceeding to close the escrow. And then option three is, hey, gosh, you guys asked for 48 things, but I think that these 6 are the most important. That's what we're going to do. So that's, those are the three options and how they work. If the seller says no, they're not doing anything, or they counter what the buyer is asking for, then you as a buyer, you have 5 days to decide if you're going to cancel or not. That gives us as realtors lots of time to negotiate, to try to keep the deal together. Hey, if you guys can't do this, my people are walking type thing. Then we talk about home warranty plans. Some people don't like home warranty plans because they see them as just, gosh, a waste of money. And once someone's been in a home for a year, we always encourage them to think about it, because then they know the house. They know what's going out, what's good and bad, so they can make that budgeting decision. But that first year, we found there's nothing worse than to sink a lot of cash into closing costs and earnest money and do all those things, and you're moving in, all those moving costs, only to find out the AC quits working or the hot water heater goes out. Well, it's nice to have that home warranty plan in place to protect you. And then, just so you know, the buyer has a right to do a final walkthrough. You do that to make sure the place is still standing, the door hasn't been ripped off, or windows aren't broken. And oh, by the way, did the seller make all the repairs they said they were going to make? And the seller needs to allow you the opportunity to do those inspections and walkthroughs. And then there's a little note here that says, oh, and by the way, the IRS will report about foreign investors. And that's also, the title company has to report about that in terms of, funding. If you netted, $1.5 million in gain on your personal property, that exceeds the waiver on taxes. So there's going to be some tax coming in. The remedies, section 7. No one wants to talk about this. It never is an issue unless somebody's unhappy, or somebody wants to cancel, or somebody does something wrong. And so every contract has to have this part of it, which says what happens if someone does something wrong. It used to be they just cancel it. Not anymore. It's very fair. And it says if one party doesn't do what they're supposed to do, the other party has a right to say, hey, you didn't do what you're supposed to do. And they send them a cure notice. Once that cure notice is sent over, it says, hey, you didn't do this. The contract said you're supposed to do this, but you didn't. The potential breaching party has 3 days to cure that potential breach. If they can't cure that potential breach, then it becomes a breach. And then if it's a breach, it becomes, if you're a buyer, okay, and you breach the contract, most oftentimes the seller will take your earnest money. They have rights to go after more if there's more there, but that's 99% of the time what happens. And if a seller breaches a contract, it's just not a good thing at all. Opens that seller up to huge liability. So our job is to keep our clients out of that situation. But if two parties disagree and it becomes contentious and the thing crashes and burns, which on our team we don't see that hardly ever, it in fact never practically. But if it does, then both parties agree to go to alternative dispute resolution. They'll agree to arbitration prior to going to court, unless it's a small claims thing. If it's under $3,500, you know what? It doesn't matter. Just go for it. And whoever loses owes the other party their attorney's fees. Section 8. Section 8 is about additional terms and conditions. And so we can add, there's all kinds of things we have to do. If we're doing an escalation clause, we're doing something that helps to really incentivize to win the contract, we're going to put it here under section 8, which is important. And then also a lot of boilerplate here. which a lot of people just skim by, but you can lose money in real estate. It's buyer and seller recognize it's in the MLS, and the public's advised of it. Arizona law is what governs this. Time is of the essence. That means that things have timelines to them. The realtors do get paid commission. That's what's noted in the MLS. Copies and counterparts, 2 different copies with signatures on each, can be combined into one. Talks about how a day is determined. It'll throw you for a loop every time. The day starts at 12 a.m. and it ends at 11:59 p.m. And the day of the act doesn't count. That's day 0. That'll just drive you crazy, keep you up at night. Bottom line is, if you go on a contract today, it's day 0. Tomorrow is day 1 of the inspection period. And when they say things like something has to happen 3 days before close of escrow, that's important. It's like the way that sentence is written. If close of escrow is on a Friday, okay, and an act has to happen 3 days prior to, that means it has to happen by Monday. So that's how days work. And then this section 8J, no one ever talks about it. Super important. The entire agreement. What it means, okay, is that you can make a counter offer, or you can do things or an addendum, but it doesn't change any other terms of the agreement, just the words that are on that document. Now, the seller has a right to get backup offers, and you have to give notice. It says how you have to give notice. And then there's another thing, once again, dealing with realtors. Guess what? Realtors are not surveyors. They're not environmental, specialists. They're not licensed contractors. Do they really know, if a home has termites or not? And what about building codes? We don't know that stuff. Okay. So we can, we can give guidance on where to go find that information, but you should know when a realtor says, "Oh yeah, that's a building code violation." That's not what a realtor should do unless they're licensed. They should say, "I think it might be." Well, and here's some ways where we can find that out. Let's get an expert to advise us properly. That's how that works. And it says, when you make an offer, it's only good for a certain amount of time, and then it's over. So you got to extend those. So those timelines are super important. Then we talk about who you are, who the broker is, who the buyer is, who the seller is, and there you go. So I know it was kind of boring and took a while to listen to me go through all this dull and boring stuff, but it's important. And I appreciate you taking the time to listen to what I had to say. And I want you to have a fantastic day, and looking forward to helping you with your new transaction.